With us is present this evening, Councilors Joseph, Kuchmarek, Donnelly, Clark, and Beazall, myself, Councilor Di Natale, and Councilor Boschman. We will start with 195-16, a petition of City Solicitor Vincent Pusateri II to approve the fees schedule in the attached retainer agreement and amend the code of the City of Fitchburg by inserting Section 3-59, permitting the city solicitor and assistant city solicitor to require third parties to pay the City of Fitchburg's legal fees for services performed. Mr. Solicitor.
Thank you, Mr. Chairman. I filed a petition, came out during our budget meetings that we were charging fees or intending to charge additional fees for companies that have come into town who are requiring substantial legal services in connection with their business enterprise. I routinely have been requesting those folks to reimburse the city for expenses incurred in connection with the supplying of legal services, and have suggested them to do the same, specifically by way of a contract. I've been supplying that to them. We've been negotiating out whatever those terms are and executing those agreements. So I think our council president suggests perhaps we should file a petition. I thought it was a good idea to make sure that everything is out in the open. I've had a couple of meetings with our auditor's office on the topic. I've met with the treasurer's office at least a couple of times as well. And typically speaking, the situation will arise where it might be a cultivation processing facility, might be another substantial business, and there's simply a request for payment of fees. We've had a couple with the solar or one solar farm, and the agreement is executed with the individuals, businesses. They would forward a fee. Typically, the fee will come in two separate ways. The fee will come in as a one-time fee payment to the City of Fitchburg. The more complicated situation is when there's an ongoing relationship with the company and the fee is then billed at an hourly rate. That fee gets put in something we call the IOLTA account, which is a client trust fund account. It doesn't belong to the firm. Monthly statements are generated to these companies. They come who have already executed the fee agreement. They're given an opportunity to object to the services or the amount charged for the services, and then a short period of time after that, the cash is then transferred over to the city. It's very important for all of us to understand that the Office of Pusateri and Wilson receives zero compensation in connection with any of these monies, including administering the IOLTA account or legal services supplied by myself. The long-term goal here would be to demonstrate to the council that there is an opportunity for reimbursement of legal services and a concept that at some point in time, should it be viable, to present the council with expanding the budget of the legal department. Happy to take any questions.
President Kuchmarek.
The defined parameters for exactly what type of cases would allow for fees to be issued?
There's a certain amount of discretion that's used in connection with that. Speaking with the Department of Local Services, anything that we negotiate by way of a contract is absolutely permissible. And in fact, a formal fee schedule, as I think we originally had thought, and approval of council is not even necessary. So the request will go out to anybody that's reaching out looking to incur or consume a substantial amount of the legal department's time. So there will be a certain amount of discretion that's involved in that. And again, it's a matter of contract.
So my concern is always, well, yes, it's great for us to generate new revenue streams and offset costs for us. Yes, there's a certain cost of doing business when someone looks to relocate or establish a new business. They expect building certain building fees and filing fees, et cetera. My concern on our end is, yes, there's also a cost for us to attract businesses here. Are we establishing a deterrence in doing this? And if so, what are our neighboring communities doing? And would this be a precedent for Worcester County, for example?
Yeah, I think this would be a precedent, sir. But I would add, on the issue of deterrent, I think the first instance that we had this was a solar project. It's a company that wanted the city to engage in a long-term negotiation regarding what a pilot agreement would look like in connection with their solar project, where they were looking to make a substantial amount of money. The pilot agreement being an agreement that the city might reach with that company to make payment to the city in lieu of taxes because of certain tax laws that would allow them to otherwise avoid making real estate or personal property taxes in connection with the operation of their business. Those folks are looking for the city to do something for them by getting that approval on the pilot agreement. In that case, is not at all a deterrent for them to come to the city. In fact, they had their location, and they needed the services done as far as spending the time and money, if you will, because time is money, in connection with negotiating the agreement. Some of the cultivation and processing facilities, in fact, Mr. Trigny's here, one of them remarked that we didn't charge them enough for services. So the fee request is reasonable and is intended primarily to defer the costs of the legal department. The other thing that the fee was used for recently was a purchase of one of the old mill buildings. There was a substantial problem with the wastewater. In fact, we're working very hard to control inflow and infiltration. It's something that's contained in our consent decree. Well, there was some contracting that was required in order to do a few things, which benefited the person that we were engaged with in that instance. They were actually looking for the city to negotiate a reprieve, if you will, while they worked diligently to get the inflow and infiltration out. It was a win for the city. It was a win for them because they were able to avoid some substantial costs of us receiving their stormwater, basically. And it was all done by contract and voluntarily done. If there was an objection to a fee, we would certainly reevaluate. There has not been an instance where, in 9 months now, that there was a company that was seeking to avoid doing any business with us. And certainly, we had one occasion, I think it was with Lodestar, another solar project that's percolating, where there was a little bit of a back and forth on that. But, you know, we're here to be reasonable, but also to defer the cost to the taxpayer of these other companies coming in and consuming city services in order for their own financial gain. Folks in the business world are not foreign to paying attorney's fees. It's a regular course of business. In my private practice, representing somebody who doesn't have the ability to make the fees, and I would suggest the city, as I've been understanding it, has been having some financial concerns. Ordinary course of business for us to make a request for fees, and this is in line with that practice. So I respectfully would disagree that the fear of deterring folks from coming in that this will have that effect.
So this seems a little bit funny asking an attorney this, but I guess if you're saying this is a precedent, my other concern here is, you know, we're looking to apply a fee to something that is through government. So we're asking, you know, folks they're looking to establish, you know, a business. You know, they're applying for something, and we're now charging them a fee. If we're saying this is a precedent and not typically done, are there any concerns about legality? Has this, can we get a green light from an impartial, third party, be it for the state or the Attorney General's office, to say, yep, this would pass muster?
Yeah. Matter of fact, I believe it is. That's why I'm doing it. In fact, I was completely comfortable until my good friend Mr. Nicholas made an objection at the recent City Council meeting. So I took the opportunity to contact both the Department of Local Services and the Department of Revenue. And I contacted the Attorney General's office. And we are absolutely correct. And in fact, while it is a precedent, I'm sure that if we go back through the records of the city, that there are attorney's fees that have been paid to the city for various different events, whether it be housing court violations or whatever else in which fees might otherwise be shifted. Doing it by contract is absolutely permissible.
Thank you.
Counselor Joseph.
I think the majority of my questions were answered through that discussion. My concern, like you said, is what if it's a new type of business, okay? We haven't really done our homework or prepared for it. Say a marijuana dispensing facility, and we haven't done any kind of zoning, or we haven't done any kind of, say, legal backup work, and somebody comes in and wants to put that in place. Are they going to be? Would they be expected to pay for a charge where we're not ready for them? We haven't really, we probably could have done some proactive work, but we didn't. So would we charge them to get the city up to speed on something like that?
We certainly would. The cultivation and processing area has been, in the host agreements, one of the primary sources of requesting for attorney's fees. We have one host agreement where we had requested $2,500 in attorney's fees. It was such a protracted negotiation. That was the organization that said you didn't ask for enough. And in fact, we amended the agreement to increase the fee from $2,500 to $3,500 at their request. And I think that another example recently came up, Counselor, was a couple of solar projects have been percolating, and the mayor's office and myself were engaged in the negotiations, but we came to the realization that we don't have the level of expertise to price out if some of these projects are a good deal or not. So we have to go out and hire outside people. Well, those outside services will be at a substantial cost to the city, and that's because these folks are coming to us really trying to sell us a product, trying to sell us either a service that will either reduce the city's cost but also make them money, or a product. And in that instance, I think it's perfectly permissible. And I just lost track exactly of your question, so if I'm not answering it, please let me know.
We kind of, you were saying, my question was if we're not ready for it, again, we may not have been ready for that. So
in that situation, we are going to look to pass those fees on to this entity.
Okay, and if again, we'll use the example of a dispensing facility, because we don't have one of those yet, or not in. If somebody came in for a dispensing facility and we weren't ready for it and we had some work to do, and they said, I'm not paying the city legal fees because I can go into Boston, Somerville, any place where Leominster, people that have already put them in, and nobody's charged me city attorney's fees.
In those cases, in those particular contracts, the amount of fees for attorney's fees, for reimbursement to the city for costs incurred in connection with negotiating their agreement to get them here into the city, is, from their perspective, from what I've been understanding, inconsequential. It has not been the issue. The substantive terms of the host agreement has always been the issue. Folks in that particular industry, and we continue to receive potential suitors, continue to come to the city and are asking to sit with us, and their initial draft of every host agreement contains the request that when we sign the agreement, there will be attorney's fees incurred to reimburse the city for costs incurred in connection with the negotiations and the execution enforcement of that agreement. And there is some amount. I think I've done one for $1,500. I think we had an attorney's fees for $1,000. Now I'm going to talk off the top of my head, so please don't hold me to that. So that's kind of been the range of how they've been going on the cultivation and on the processing. On the other fee, I talked about already about the wastewater issue that we had with the folks that were buying one of the mill. That really wasn't a substantial time consumption, so the fee was much less. And I'll go off the top of my head, sir, and tell you it was about $300. So nothing here is being intended to be prohibitive. In fact, most of the requests for the fees are under circumstances where the third party has a substantial ability to pay, especially compared to the city, and are all voluntarily doing this by contract, which is really the most important part of what I want to make sure that we all understand. We're not saying, we're not playing with you, absolutely not, this is what the fee is. I'm sending out the request, and they're agreeing to it.
Okay, that's all, as long as it's voluntary at this point.
If I can add, and they want that because I feel that they believe that they understand that there are costs on our side of the coin, and I think that's because they're incurring the costs as well. I mean, the firms in Boston are charging a lot of money in the connection with their representation of those folks. So what we're asking in all these situations is really a drop in the bucket.
Thank you.
Thank you.
Council Donnelly.
I know it's nice to raise revenue generators, but I know you come in for something, you got to go to the planning board, the zoning board, the conservation commission in many instances. And how does this affect us in the playing field, not with Boston or Springfield, but just, in a 10 or 20 mile radius, how many other communities which are somewhat competitors, if they're looking in this geographic area, how does this put it? And is there a threshold? Is everyone subject to this, or is, after how many hours do you get of legal services from Fitchburg before this kicks in?
Well, there's a certain, on the second part of the question, there's a certain amount of discretion that the law department has been using to request for fees. How much work are we looking at? Certainly is one of the factors. Ability to pay is certainly one of the factors. Deterrent certainly is one of the factors. We can certainly distinguish a case where we have a company that wants to profit off of net meter crediting, other solar-type projects, a company that wants to profit through the sale of medical marijuana or the cultivation distribution of medical marijuana on the one hand, and claimants, folks from the city, the constituents that are saying, we're having a legal problem and I'm filing a complaint with the city regarding maybe a sewage backup that happened at my property. There's certainly a clear distinction between those types of things. I'm sorry, in the first part of your question?
For an applicant, is there an appeal process, or is it just going to be solely the discretion of the law department?
It's currently in the discretion of the law department.
No appeal?
Well, it's not we are not laying down an absolute and arbitrary decision.
That's why
it's been a negotiation back and forth at every turn, sir. Simply looking for these parties to reimburse the taxpayers for the costs and expenses incurred in connection with their particular project.
I agree with a lot of the not-for-profits, or when people are doing a TIF or some of those things, but I can see if someone's coming in with a big project where the city's going to get good tax money, commercial project, I can't see. I want a level playing field. I'm not trying to gain, I don't want to see us gain a few dollars in the short run and then not be appealing to developers as appealing to developers and gaining money in the long run.
Yeah.
So-
It just is a situation that hasn't presented itself.
So if a small business comes to the city You mentioned about ability to pay. To make it clear right now, you're not saying that if the solicitor or the solicitor's team determines that this is a client that will warrant reimbursement, you present the contract, you negotiate, and they say to you, we're not paying anything, period. Just for clarity's sake, we're not saying that we're going to then not continue our prospective relationship forward with that business if they refuse to pay.
Correct. And I want to add, as you're asking that question, and just to follow up on Councilor Donnelly's question, the mayor's office certainly would set a standard and direction on this. So, for example, we have an entity that's looking to occupy a space over where City Hall is currently located at the. There's been some time spent on that, but there's been no request because that is seen by the mayor as a high priority to resolve that as quickly as possible and to do what we can to get those folks in. It's the folks that are really profiteering. It really has been very limited to the cultivation and processing, the solar or the power agencies trying to come in and discuss terms. And then there was that one instance where we had to make a special contract in connection with the wastewater.
Yeah, and these companies are not being forced. They are willingly signing these contracts saying, yeah, it makes sense. And it seems like it's being zeroed on companies that are coming here to profit, where the cost to them to go through this process is inconsequential to the whole end game that they seek.
Every single one of them, sir.
But as you said earlier, just for clarification, we will not be not working with prospective businesses in the event that comes forward that we present them with a contract that we want to negotiate with them and they say, no, we're not playing. The mayor, obviously, I would hope, would have the discretion to say, listen, we're obviously going to keep working with them. We're not going to say, no, if you're not going to pay $1,000 to the city, we're not talking to you.
So the mayor's office has got this on economic development on his front burner at all times. And any of these opportunities that are percolating have been reviewed with the mayor's office. We had an informal meeting today with the cultivation and processing company. There wasn't I'm not showing up unless you pay a fee. If they get serious and they want to start working on terms of a host agreement and making a plan for the planning board or maybe a variance is required under a certain circumstance, and they want the city to evaluate that with them, that's a possibility that we'll get to a point where we'll begin to say, okay, there's a lot of work that you're asking us to do here. And, the citizens for the city of Fitchburg would not like to pay for it. For example, some of the host agreements that are actually executed may never come to fruition, and that's why this council haven't seen that, because some of these folks won't actually get through the licensing process in Boston, never mind. So why would we spend such a substantial amount of time? I do, and to a certain degree, and private practice too, use the retainer request to gauge seriousness and commitment, whether or not the folks are actually committed to the project before we dump our resources into their project.
So this has to be in a negotiation where both parties agree. Failure for an agreement does not mean that there won't be any moving forward on any type of help from the city. I recall, because I've been very vocal in the past about legal service privatization, I remember the former solicitor and the one before him would continuously combat my argument by saying that there are one or two instances every year in the city that warrants so much of their time that everybody else takes a back seat. And then I heard someone say about, well, competitiveness with other cities and towns. In the city of Leominster or Gardner, where they pay a private firm, that firm is billing them by the hour. So in my opinion, because this is what I'm always fed by previous solicitors, they're billing a substantial amount of money to these cities and towns for that one specific project that the taxpayers got to pay, and we're not getting any reimbursement from the company that's requiring those services. In this instance, our attorneys are salaried, but I just wanted to make sure that this is legal. We've passed this through the necessary channels, the Division of Local Services, the Department of Revenue, the Attorney General. This is voluntary, it's not mandatory, it's an agreement, and it seems to be in specific cases with companies that are looking to substantially benefit or gain from their business in this city. And my only other question, probably to the auditor, is you mentioned that we've already been receiving some reimbursement.
Yes, we've executed contracts with folks.
So where has that money been going?
It goes in the general fund.
So that was my other concern was it's not going to the attorney, it's not going to the firm, it's going to the city's general coffers. Is there a line item in the status sheet? I know every department has a revenue line item. Will there be a formal revenue item under the legal department that will allow us to see what this is generating, or is this so basically where's the money going to right now?
Right now, we added an account, law department miscellaneous.
Okay.
So when funds come in, they'll show up on that line item, right within the budget,
Okay.
right near their budget.
President Kuchmarek?
Counselor, Mr. Chairman, can I just interrupt this one question just to add, because it was important for me, and I'm sure for the auditor, to make sure that we made a plan so that all of the billing and the money is easily accounted for. And we have developed that over the course of a couple of meetings, and certainly going to have a processes so that the auditor's office makes it an easy task for him to account for the money, to know that everything that comes in is actually received, and it's received by the city of Fitchburg.
So is this client retainer agreement we got in our packets, is this
That's
just an example, or is this
This
subject
is a sample,
to
and I'm
revision?
certainly open for comment and criticism on the agreement. I'm sure my friend Attorney Nicholas would like to give me some. I'm interested to see what he has to say. But my suggestion on the agreement was just to give you an idea of what I'm looking at, and perhaps if we do, if this committee chooses to make a positive report to council, the report might include that this agreement might be modified in the future as we continue to get into this process.
So we would just be in effect allowing you to go forward with this process. This is not an ordinance requirement?
You know, this came from, I think, a very well-reasoned opinion from the President Council that typically fees are memorialized in an ordinance.
Right.
And I think when we first, at the budget hearing, heard the term fees, that said, well, we should probably have an ordinance. And I think having this out in the light of day is important.
Would this generate an ordinance?
After some initial comments, I did contact Division of Local Services, and they said, no, it's not, as long as it's all being done through contract.
Yep.
So it's not necessarily a fee schedule.
So then this is just an example. These numbers are subject to change on a case-by-case basis.
And in fact, if this committee was to recommend not to change the ordinance, the practice could actually continue to go forward. Obviously, if you entered an order to not have me do this, I would stop doing that. So there is no, after I filed this petition, after receiving some feedback, I did contact local services to confirm that I was in the right. Not only is it a correct practice, but we can do it by contract in Division of Local Services.
So am I hearing you correctly, Mr. Solicitor? You're saying that this doesn't even have to come before us?
I don't need
This
an
is
ordinance.
this
to
is
do
a formal thing you're doing in conjunction with the president to make it sure the public's aware and.
Absolutely. I think the president was right to make sure that the public was aware. I think folks have concerns, and I think Councilor Donnelly's concerns are not, should be aired out, and it's something we could have a conversation about.
Just wanted to clarify that. Okay. Thank you. President Kuchmarek.
So I just want to confirm with the retainer agreement, as I see there, that, am I correct? That's in this case, it's between Pusateri and Wilson and the client.
Yes.
Okay. I guess my only concern there is, and again, I realize this is just simply a sample, but if we are adopting formal language, that, I'm curious: is there any way it could be between the city? Should it be phrased in such a way that it's, and I hate to get into the weeds here, but phrased in such a way that it's, Presterian Wilson on behalf of the city of Fitchburg. My concern here is any time, and I have no distrust of you, your firm, or any future firms, but I'd like it to be explicitly clear that this is a retainer between
Sure.
the city of Fitchburg, the organization, and the petitioner or the client.
Yeah, I think that's a valid point. Yeah.
Is there-
And, I certainly could amend that contract to remove any ambiguity.
Is there a legal and financial infrastructure to allow for an IOTA account to exist under the city's umbrella and not under a particular? Okay.
I don't know the answer to that. I'm not going to say I don't think so, but I don't think so, and I have to get a further investigation on, because the IOTA account would have to be done. I would rely on the auditor's office or the treasurer's office to help establish the financial account for that. And honestly, this was one of the first agreements that we really did throw together fairly quickly, because we were accommodating somebody that wants us to really drop everything and work on their project. Sure.
So this,
Mr.
I'm sorry, go ahead. I'm sorry.
Saracen, does that at least,
Yeah, I
you know,
think,
in principle, sound like the city could be the kind of the fiscal agent in this?
I believe so. We have had in other cases where we set up an escrow account that would hold the funds. And I think a meeting with myself, the treasurer, and the attorney, we could resolve that.
Yeah. The IOTA account, and Attorney Nicholas can correct me if I'm wrong, has to be managed by a law firm, and I could be in that case. A lawyer. Okay. So we might be able to do that by having me as a signatory on that account under the name of the city.
And it may not, I think we defer to the legal, because it may not have anything to do with the city until the services are provided anyways. But they may be retained in an account before anything is due the city. But once it's due the city, then we could facilitate either going in the general fund or going in the escrow account until it's resolved.
And on a couple of occasions where the fee agreement has been used, monthly bills have gone, nobody has contacted to make a complaint. Nobody has said this has been an unreasonable amount of billing, or, in fact, the billing has probably been light. So, and that's a function of keeping track of my time as I work on the folks' projects.
So my other question is, I look at, so we have fee structures elsewhere in the city, as you've referenced, Mr. Solicitor. We have building permit fees, et cetera. My concern here is that there might not be consistency in the process in terms of how we look at fees or fee structure, that a building commissioner, I could be wrong, someone please correct me, can he waive a building permit fee at his discretion? Similarly, could that happen on the Board of Health and other areas where fees have to be filed? So my concern is I would hate for someone down the road to come to us and say, well, that was arbitrary in terms of the fee structure assessed, or how come us? Because, so you said we're an economic priority, but they're not, or vice versa. And while I agree, I don't want to see someone who, or a business that is an economic priority to the city be charged a fee. I would hate for someone to come back to us later and say, well, that was arbitrary and capricious. You denied me when I asked for an exemption to that, but you didn't someone who you thought was a better fit. So I hope you don't take issue with my questions. I think these are, I think this is an innovative way, and I'm glad we're having this discussion. I just want to make sure that we're clear and consistent across the city and all of our channels, that we're approaching this the right way, and that we're being as transparent as possible as to when we waive, when we don't waive, and what the fee structure looks like, and at what point do we, and how do we adjust the fee structure accordingly?
I would hope that doesn't happen, because as I asked earlier, I would really hope that the city does not turn anybody away if there isn't an agreement struck. It doesn't sound like obviously that's not the goal, but I think some of us have made it clear tonight that won't be acceptable to us if that were the case. And I think I would hope it's common sense on the administration's part. So,
So, I know Attorney Nicholas has something to add, I think, and I'm happy to receive his comment.
I would allow him to speak if the committee doesn't have a problem. Any objections from the committee? Before we have Mr. Nicholas speak, I just wanted to ask one more thing about the process. This petition does reference City Code 3-59, so this would be coming to us for an ordinance.
Right. And, I'm reporting to you.
Yep.
Subsequent to the filing of the petition, Division of Local Services says I don't need this as long as it's being done by a contract. I wanted to leave the petition on because I know that there was some objections to it, and it is a practice that I intend to continue, and I think that it's fair to let everyone have an opportunity to have a conference about it. Thank you.
Okay, so if the committee were to vote on this, let's say favorably, and the council were to vote on it favorably, either we keep it as is, which would then require an ordinance change, or we strike that language from the petition, so there is no ordinance change.
Or you could alternatively vote to make a recommendation that this practice discontinue.
Right.
I guess you could
Yep.
vote to do that
Okay.
as well. And, it's a matter that's in your committee now.
Okay. Attorney Nicholas, did you want to speak?
I would like to, thank you.
Yes, sir.
Would you state your name and address for the record, please?
David Nicholas, 699 Iron Hill Farm Road, here in Fitchburg. I'm here to actually support what you're saying with concerns, which is voluntary as opposed to involuntary, because the way I look at this particular petition, it's counterproductive. What you're going to be doing is adding an additional expense that is completely, as my brother has said, discretionary. So nobody knows what it's going to be when they step into the initial aspect of the process. And not knowing what your costs are going to be as a business person makes you more reticent about choosing that locale over another locale that may be exactly the same or at least comparable. And Vinnie is right about a lot of stuff. We've got a lot of new matters that always come before attorneys, come before the city council, come before the city, period. And some of those take a lot of time. And let's take the soccer complex for an example that is now pending in the process of attempting to get all the permits that are necessary to be able to operate in West Fitchburg. If those are going through that process on each one of those steps, well, you got to pay the city some attorney's fees in order to be able to really address them, ignoring the conflict of interest that may exist here in trying to deal with two masters. One, the party that's coming before the city to do something, and secondly, your primary representation, which is the city itself. You've got a huge problem in dealing with that entity or that individual and saying, well, each of those processes that you go through, you're going to have to pay us some additional money. If it's going to be completely discretionary, or completely voluntary, I should say, that should be in bold language at the top of the document so that it is absolutely positively clear to anybody that is coming before the city. You don't really have to do this. As we all know, there are a lot of quote-unquote voluntary things that we do and that other people do or have to contemplate doing that aren't really voluntary. You've got to do it in order to play the game. And that's not what this city needs. We have enough problems already in attracting new business, and we don't need to put up another roadblock to do that. So while we may get a few people that pay $1,000 or $2,500 or even $3,500 or whatever, and I've heard that this process has already been ongoing for 9 months or so at this point in time, it could cost you that project where somebody wants to come in and build a rather substantial new tax basis for the city, but they're told, no, we're not going to allow you unless you do X, Y, Z in reimbursing the city some attorney's fees. And that one loss can upset the whole apple cart and put you in a negative, as in the soccer complex, if indeed that were to go through. If they pull out because we've already got enough objections from the neighbors and we've got to go through the other processes, and we have to also deal now with the city solicitor charging us some money, are they going to stick with the process? And if the answer is no, because that just tips the apple cart for them, then what is the loss to the city in new tax revenue? So that's a serious concern I have. The other concern I have is what has been described as discretion. The city solicitor, the mayor, they're all saying we have discretion, we can charge or we don't charge. Nobody knows what's going to happen. And Councilor Di Natale, as you said, if it's not consistent, you're going to have people say, why am I doing this when somebody else is not? And it's just, I'm ignoring what I see as serious conflict of interest issues, but if Vinnie has obtained some opinion from various state agencies, I'll rely upon him to provide that to you if you ask for it, and I'm sure that he's asked the right questions, and you'll have the opinion that you believe you may need as well. But there's just too many soft spots with what happens as far as the legal services are concerned, and in addition to that, soft spots with the discretion on who's going to pay and who's not going to pay. And the final comment I want to have with respect to this, and I'm addressing strictly economics, the final comment is, while we are dealing with the folks sitting around the table now and the current mayor and the current city solicitor, in 5 years, 10 years, 15 years, we're going to have different people sitting in those positions. Are each of them going to maintain the same policy if it's not specifically stated? Or are they going to say, well, you know what, we think it's worked, let's try to push the envelope a little bit further? And I will represent to you that oftentimes that is what happens. We do pay, I say we, business entities do pay other attorneys who represent the party that they're dealing with, primarily when they're obtaining loans. They have to pay the lender's counsel's fee. They don't get to choose that person. And an attorney, an entity coming into the city of Fitchburg doesn't get to choose who their counsel is if we say one of the attorneys you're going to have to pay is going to be the city solicitor. And the city solicitor really has oftentimes an adversarial position with the attorneys that are representing the entities coming before the boards.
All the time.
All the time. Excuse me.
Sir, I apologize.
No, actually, they don't have it all the time. If you work together, you don't have an adversarial position. But those are my comments.
Thank you.
Thank you for the opportunity to speak.
Thank you, sir.
I would, in hearing all the comments that have been made and reading the wording of the petition, I think the petition needs amending. I don't know how the committee would feel about a recommendation to the council. I'm kind of torn at the moment about whether we should codify this or not. If the council feels that this is a acceptable practice that makes sense and addressing the concerns that Attorney Nicholas raised about consistency, if there is a new administration or a new city solicitor, maybe codification would be acceptable. Where I'm torn about it, though, is that if the state attorney general's office or other state agencies have said you don't even need to codify it, I mean, short of this council saying we disapprove of this practice, we don't want you to do it anymore, there's nothing legally stopping the city from doing this. So my suggestion, I have one counselor who wants to speak, would be to strike the petition's wording, starting from approved to agreement, because my opinion is we shouldn't be setting any set fee amount because it's a negotiation, but instead say permitting the city solicitor to enter into negotiations with willing third parties to pay the city of Fitchburg's legal fees for services performed. And I added that word willing to maybe give some people, including myself, some comfort that no one is being forced to do this. And we don't want to discourage anybody from coming here if there isn't an agreement. So the willing is an important word for me anyway. That's my 2 cents on it. Counselor Beazle?
Thank you. So, Vinnie, when we're looking at this, so if I want to set up a pizza shop, basically, I probably wouldn't even be involved with you to begin with because we already know what it takes. It sounds to me what you're dealing with is something out of the ordinary. Now, I know medical marijuana is something that is brand new, and we haven't heard a lot about it. So I want to set up a place in Fitchburg, and my attorney is Dave Clark. Okay, you're a good attorney. We come to you and say, hey, Vinny, this is what we want to do. We want to do X, Y, and Z. Now, are you saying to them, well, I'm going to have to research that because I'm not quite familiar with how that pertains to the city of Fitchburg, so I'm going to get back to you in a month's time with how I feel about it. Is that what we're talking here, or?
Just so that I understand your question, Counselor, the routine business, like the pizza shop that you made reference to, is probably not, clearly is not what we're talking about. In fact, even with the soccer fields, that's been a priority of economic development. That's not a situation. It really is these other extreme situations, getting involved in trying to negotiate a deal benefiting your new business regarding the inflow and infiltration into our sewer system, and the solar farms and those are the 3 categories where I've implemented the request for the fees. So I might say to them, I'd send them either a retainer request or we would begin to negotiate the agreement, and I would raise the specter of there would be some cost that the city incurs in connection with your project for legal services early on, and that becomes part of the conversation and will usually be one of the clauses at the end of the agreement. Have I answered your question?
So I guess my question would be, if let's say you didn't do the legal work, how would the legal work get done? Like, I'm a business and I come to you and I say, I want a deal on the sewer. What can the city of Fitchburg do for me? Because I want to be partners with you, X, Y, and Z.
Mm-hmm.
Who else would do that type of work to actually go and investigate what kind of dealings could take place?
They would hire their own attorney to do that. I think that would be one way of doing it, and then their attorney would then work directly with your wastewater department in connection with the contracting on that. But inevitably, that will eventually come to the legal department to review, finalize, or work out, or perhaps peer review what the prospective entity's attorney has already done. So at some point in time, it's got to come to the law department.
Okay, but so if I went to you and I said, something, I don't want to get my own attorney, I want to work with you, just do the work and bill me for it. Is that what normally happens? Or?
Well, just to be clear, in light of my good friend Attorney Nicholas, the conflict of interest would come up immediately, and the very first thing the folks have to be advised is, I represent the city of Fitchburg. So you have to understand, as we get into the negotiation process and or the contracting process, that's my responsibility. I'm happy to sit down and work, and I don't disagree with my friend Attorney Nicholas here, that as a team with prospective businesses, much as we did with the soccer field, much as we did with the cultivation, a handful of cultivation folks, and with the people at 431 Westminster Street. We're going to work together, but I have to ultimately advise these folks that I represent the city, and they cleared through that hurdle, and I'll say, listen, it's a complicated issue what you're asking us to do. it's going to incur a substantial amount of time away from addressing constituents' complaints regarding insurance issues, preparing and drafting ordinances or orders as a result of council votes. So to a certain degree, the taxpayers of the city of Fitchburg should be compensated in connection with that. I think some of the better examples are the solar projects. I mean, these folks, they're salespeople calling us. I want you to negotiate this with us. They want to sell us this service or product. I mean, that's really, and I guess it's my fault to not provide you with a more articulable basis as to how that discretion. So perhaps the best thing to do for me, maybe even draft something along that line. But Councilor DiNatale's remark of willing to negotiate, you could use terms like that, a fee, willing, those types of terms I have no problem with. I'm certainly happy for any further input like that.
Council Donnelly.
Thank you. We have the fear of the unknown. And my biggest fear at the moment is the lack of a level playing field and the fear that somebody that wants to start a relatively small business may think they're starting a big business because to them it's a big business. And if you do it in Fitchburg, you've got to pay your attorney and you've got to pay the city attorney. What's the definition of big? What's the definition of discretion? If it was more definitive, the fear is it starts with Fitchburg and its lack of easygoing, it's easy to do business, it's easy to get a permit, and now it's becoming more expensive. It's perception. It's not reality. And what we are dealing with is perception. And we have to overcome a negative perception. I mean, there's more happy people in the city. There's only a small percentage in a few bad neighborhoods and a few bad people. They're the ones that make the newspaper, not the good guys, not the 80 and 90% of people. And my fear is when you're talking development, a new business, a new small business. Why is Main Street empty? It's just it's so many little things that make a big thing. And it's fear of the unknown. If it was more specific, I think the idea is great, to a point. But how do you explain that?
Sir, Mr. Chairman, I might remind you, I had another commitment I have to be at. I'm already late for, and I have to respectfully ask if I can leave. And I would respectfully ask perhaps a continuance to your next Finance Committee meeting to flush out some of these details. But unfortunately, I really do have to leave as a result of an important prior commitment.
About one-sentence statement that might help for the next future meeting. Mr. Solicitor, I think what would be helpful is if you could maybe perhaps draft some language that would better help to define what third party might be, so we really kind of hone in on the specific examples that could occur, and it might assuage some councilors' concerns.
Happy to do it, sir.
Make a motion to hold 195-16.
Second.
Motion made and seconded to hold 195-16. All those in favor of holding?
Aye.
Opposed? It is held.
Thank you, councilors.
Thank you. Next, we'll go to 206-16, petition of Councilors Bean, Boschman, Green, Beazall, and Clark to restore the option to allow the city council members to participate in health care benefits.
Motion to give 206-16 leave to withdraw.
Second.
I apologize. To deny 206-16.
Second. Motion made and seconded to deny 206-16. Speaking on the motion. All those in favor?
Aye.
Opposed? It is unanimous. Councilors, next we have 210-16, that the City of Fitchburg approves the expenditure of funds from the Mass Office of Public Safety and Security for the FY17 State 911 Department Support and Incentive Grant in the approximate amount of $115,227 for the purposes of said grant. I have a letter from Chief Martineau. Dear Honorable Mayor, Fitchburg Police Department has received an allocation of funds totaling $115,227 from the Commonwealth of Mass Executive Office of Public Safety and Security State 911 Department. These awarded funds are intended to support the salaries and/or provide repair and enhancements to our department's E911 service system. Our goal is to defer the compensation of certified E911 dispatch call takers with this resource. I request your approval to start spending down these funds effective immediately. Chief Martineau.
Motion to grant 21016.
Second.
Motion made and seconded to grant 210-16. Speaking on the motion, Counselor Joseph.
Just a clarification, he indicated that he's going to use that to train the dispatchers?
These awarded funds are intended to support the salaries and/or provide repair and enhancements to our department's service system. Our goal is to defer the compensation of certified E911 dispatch call takers with this resource. Schroeder?
I believe that amount was in the budget, and it reduced the gross salaries of the dispatchers. So the city has been planning on these monies to come in to supplement, or the budget might have been $400,000 for that group, but we passed a budget of $300,000. So most of it is for their compensation.
Which is allowed by the grant.
Yes.
Okay.
Motion made and seconded to approve 210-16. All those in favor?
Aye.
Opposed? It is unanimous. 211-16, order that the City of Fitchburg approves the expenditure of funds from the Federal Department of Justice, Office of Justice Programs for the FY17 Local JAG Award, LLEBG 20, in the approximate amount of $28,415 for the purposes of said grant. A letter from Chief Martineau dated August 11th to the Mayor. The Fitchburg Police Department has received an allocation of funds totaling $28,415 from the Department of Justice, Office of Justice Programs. These awarded monies are intended to continue replacing current police radios and associated equipment, purchase 4 mountain bicycles to outfit the community policing unit, add an AED defibrillator to our community room, continue our system improvements project, and support community policing mobilizations. I request your approval to start spending funds from this award to benefit both our department and the City of Fitchburg. Thank you for your attention to this matter.
Motion to approve 211-16.
Second.
Motion made and seconded to approve 211-16. All those in favor?
Aye.
Opposed? It is unanimous.
Motion to adjourn.
Motion made and seconded to adjourn. All those in favor? Opposed? We are adjourned. Thank you.